Good afternoon, folks. We're here for first appearance hearings.
Good afternoon, Judge.
Good afternoon. Okay, there's three purposes for this hearing. The first purpose is to determine if there's probable cause for your arrest. That means, of course, whether there's reasonable grounds to believe a crime may have been committed and you're the person that committed it. If I find there's no probable cause for your arrest, one of two things will occur. I may give the state 24 hours to produce additional facts to show probable cause, or I may direct you to be released. If you're released for lack of probable cause, it doesn't mean the case is over. It only means you'll be released from custody, and if the state wants to proceed against you, they have the right to do so. The second purpose is to determine whether you should have a lawyer appointed to represent you. You have the right to counsel. If you have your own attorney and you want him or her present, let me know that, and I'll direct the bailiff to attempt to reach that lawyer. If we can't reach your lawyer, this proceeding will have to be delayed. If you want to have the public defender appointed to represent you, please let us know. I'll appoint the public defender to represent you if you qualify for their services. You must fill out completely an application for indigency, which will be provided to you, and the clerk of court will determine if you meet the statutory criteria for having a public defender appointed to represent you. You'll be charged $50 for the processing of the application, which is due 7 days from the date of the application. Please understand that the public defender is not free. If you eventually enter a plea of guilty or no contest, or if you are eventually found guilty of the offense with which you've been charged, then a judgment may be entered against you for the reasonable value of the public defender's services. The third purpose is to determine what type of pretrial release, if any, should be set in your case. You may be released on your own recognizance, you may be released on a pretrial release program subject to certain conditions, or I may set a monetary bond. Each of you has the right to remain silent. You're not required to say anything, and anything you do say can and will likely be used against you. You also have the right to communicate with counsel, family, or friends, and if necessary, you'll be provided with reasonable means to do so. Please come to the podium when your name is called. Tamara Solkeld.
North Broward, Your Honor.
Thank you.
Good afternoon, Your Honor.
Good morning. Good afternoon.
George Jordan again, standing in on behalf of Mr. McLawrence. I first asked the court to, if she qualifies, to deem Ms. Salkeld indigent and appoint Mr. McLawrence's law office to her case.
Okay. Ma'am, are you presently working?
No, ma'am.
Okay. Do you have any assets?
Yes.
A car, a home?
No.
Okay. All right. I'm going to find that for the purposes of today, she's eligible for the appointment of counsel.
Thank you, Judge. And I'd ask the court to get involved. It's don't have a PC exact from the original listing in front of me, but the charge is one count of possession of a shopping cart. I would only assume that facts can't be too egregious to where we can't resolve that today.
Yeah. Okay. So, ma'am, you're charged with having failed to appear in court on a charge of possession of a shopping cart. That capias has a $100 bond. If you want to resolve the case today, rather than, yes, okay?
Yes.
All right, then on your plea of no contest to the charge of possession of a shopping cart, I'm going to find you guilty and sentence you to time served. Okay, good luck to you, ma'am.
Thank you.
Jennifer Russell? Did you say Paul Ryan?
Yes, ma'am.
Yes, ma'am.
Okay, thank you. Okay, good morning, Ms. Russell. You're here on 2 additional counts of violation of felony probation. No bond is available as to those. I do find probable cause. You're going to have a hearing on your violation of probation on August the 8th. Good luck to you, ma'am.
Thank you.
Erica Smith.
Your Honor, the jail has requested if the court could call Mr. McIntosh. He's at the very end of the docket. He's in the main jail.
Okay.
David McIntosh is here present, Judge?
Oh. No, I thought you just asked that he be called at the end of the docket?
He is at the end of the docket.
Oh,
He's
okay.
the last case on the regular docket.
Okay, okay. And Erica Smith will recall? All right. David McIntosh, yeah, you're here, sir, charged with a violation of your parole. No bond is available. I do find probable cause for those charges. Good luck to you, sir.
Judge, briefly, I know Mr. McIntosh was saying that he needed to be screened to take his proper medication. I know he's in medical right now. I don't know if he's already gone through the screening. In the abundance of caution, if my colleague can drop an order, could you sign an order having him medically
Absolutely, to be medically screened. Yep, absolutely.
Thank you, Judge.
Good luck to you, sir. Okay. Let's recall Erica Smith. Where was she?
Ms. Smith is here present at Maine, Judge?
Okay. All right. Ms. Smith, you're here this morning charged with driving while your license is suspended with knowledge as a third or subsequent offense. Bond is set in the amount of $750. You're also here on 3 separate misdemeanor capiases. 2 of them are for driving while license suspended with knowledge, and 1 of them is for operating without a valid driver's license. Those capiases are setting $500, and no bond on 1 of them. I do see that your driver's license is suspended, and you would be looking at habitualization if you were to resolve any of these today. So you might not want to resolve anything.
Just for the court's edification, count 2 is also a failure to appear at a VOP. That's why it's no bond.
Is a failure to appear at,
A violation of probation here.
oh, okay, and a failure to appear at a violation probation, that's the one that's the no bond. I do find probable cause for the charges. You're due for a status on 1 case on August 9th and the other on August 10th. Good luck to you, ma'am.
Judge, briefly, and speaking of Ms. Smith, I know sometimes her hands are tied, but she did advise me, Judge, that she's a single mother. She has 3 children. She just gave birth to a newborn. Right now, her grandmother is taking care of children at this time. Judge, I would be asking you to, I know on the no bond is a VOP, there's really not much, but she's going to see her judge on August 9th. Would you, on the remaining counts 1, 3, and 4, would you place Ms. Smith on a pretrial? Therefore, if she's able to resolve her violation of probation, which is on count 2 on the 9th, then there will be no impediments of her being released, and then she'll be able to be there to take care of her kids.
Your Honor, Ms. Smith is just not a good candidate for pretrial. She doesn't come to court. Her last arrest before this, it was in 2013. That was from a 2012 failure to appear on a DWLS. I mean, we're here on multiple failures to appear, and the only reason she was arrested is because she was unlawfully driving again.
Yeah. Okay. I'm
She's
gonna.
right now very, normally I understand the stakes with her, but she's in a dire situation in which she needs to be out for her kids. And I understand on the VOP, we can't do anything. But if the judge on the violation of probation, for some reason, if they manage to resolve it by placing her on probation, then I just don't want the other counts to be holding her up. That way she'll be supervised by pretrial. And if she pleads out to probation, she'll also have a probation officer. So there are 2 assurances that are going to be in place.
Well, why can't all of this be resolved in a single appearance in front of
Because
the?
count 1 hasn't been filed yet, so it's going to probably take the state about maybe a couple weeks to file on count 1. Count 3 and 4, it seems like it's from a different division. It seems like it's in division MJ. So that's why I'm asking that request.
And I'm sorry about her situation, Your Honor, but disabled, she'll be supervised, so there's no need for concern. Count 1 is a new basis for a violation of her probation.
Right. Okay. I'm going to leave it as it is, and certainly you can take it up with the division judge. It looks, well, I can't tell if the other two capiases are the same
I
division.
believe they're all with Judge Diaz, Your Honor.
Good luck to you, ma'am. Okay, Veronica Miller.
Ms. Miller is approaching the judge. She declined the service as public defender.
Okay. Good morning, ma'am. You're here this morning charged with possession of cannabis under 20 grams. Bond is set at $100. I do find probable cause and a violation of your probation, as to which no bond is available. I find probable cause there as well, and you'll have a hearing on the violation of probation on August the 14th.
Your Honor, we have a, I don't know if she had any questions, Your Honor, before.
Oh, okay. Good luck to you, ma'am. Did you have any questions? Apparently not.
We have a Spanish interpreter present, Your Honor.
I'm sorry?
Spanish interpreter is present, Your Honor.
Oh, okay. Christopher Lawson.
Mr. Lawson's here, present judge. He wanted to inquire if his bond has been posted.
Well, look.
Thank you.
I'm not showing.
We're not showing that the bond has been posted.
Thank you, Judge. In the alternative, then, Judge, would you consider resolving Mr. Lawson's case?
Yeah, Mr. Lawson, you're here on a misdemeanor capias for failing to appear on an operating without a valid driver's license charge. I do find probable cause. The bond was set at $250. Did you want to resolve this with a plea of no contest this morning?
Yes, ma'am.
Okay, on the operating without a valid driver's license, I see that your driver's license is still suspended. I'm going to adjudicate you guilty, sentence you to time served, and there's court costs and costs of prosecution that total $293. You'll have 90 days from your release from jail to get those paid. Good luck to you, sir.
Thank you.
Jeffrey Northcutt.
Mr. Northcutt, come on up, please. He's here, President Main Judge.
All right, sir, you're here on a misdemeanor capias for failing to appear on a battery charge. Bond is set in the amount of $1,000. I do find probable cause.
Your Honor, this is actually an unserved summons capias that was issued by Judge McHugh. So, excuse me, since this is the first time he's appearing before a judge, I would just ask if the court could issue a domestic violence no victim contact order. The listed alleged victim is Tashana Barton.
Barton?
Barton, yes.
Okay. Mr. Northcutt, in the event that you post bond, you're to have no contact with the alleged victim in this case, Ms. Barton. Okay, good luck to you, sir. What was the
Judge,
first name? Deshana? Deshana.
I gave the name to the clerk so she can prepare.
Thank you.
Judge, if we could be heard briefly. Mr. Northcutt is 25 years old. He's been residing in our community his whole entire life. At this point, he's not employed. He's receiving disability. He gets $735. As Mr. Lunder did say, this is a domestic situation. He is living with the alleged victim. He does understand the no contact. He did assure me he'll be living separate and apart from her. He'll be residing with his mother. He doesn't think his mother can afford to post his bond. If you read the probable cause affidavit, I had a chance to first speak to him, and then I wanted to verify because it's kind of the first time I heard of this. He realized that there was an outstanding capias. He called the police department because he couldn't drive there for them to pick him up at his house, so he wanted to turn himself in. And I believe the first line in the police report said something to that effect, where he called the police to tell him where he was to turn himself in. Judge, I'd ask you, it doesn't seem from that sentence that he's a flight risk at all. I would ask you to consider pretrial release on Mr. Northcutt's behalf.
Your Honor, this was a capias that was issued by Judge McHugh. I would ask for the court keep it in place and that any motions to have...
On one hand is that... I'm sorry, go ahead.
Any motions to have it modified should be filed before Judge McHugh.
Well, Judge, the state just asked you to modify it the way they wanted to by asking you to impose a no contact domestic violence order. Now they're saying, well, I can't. That doesn't seem fair.
No contact order is no modification of anything.
Okay. Where are you gonna be living, Mr. Northcutt?
With my mother, she's my payee and she's my overtaker. She watch over me.
You understand what no contact means?
Yes.
You understand that means absolutely no contact, no telephone, no driving by, no touching, no talking, no visiting.
No problem. Got a month off.
Okay, even if she says, I feel bad that I did this, come on over, I'm gonna drop this prosecution, you still would have no contact, you understand that?
No contact. Yes, I understand.
Okay,
Just, and to advise the court, because I didn't think we were gonna be getting into Mr. Northcutt's priors, 2012, a burglary of an occupied dwelling, he violated his probation. 2011, possession of, I can't pronounce it, but a felony controlled substance, he violated his probation as well in that case.
okay, all right. Under the circumstances, I'm gonna go ahead and let him be admitted to pretrial release. You'll need to report to pretrial release, before the end of the day today, or if you aren't released in time, no later than first thing tomorrow morning by 10 o'clock tomorrow morning, and abide by all the conditions that pretrial release sets. Good luck to you, sir, and again, no contact with Tashana Barton.
Here's the map. See how the arrow has it? It's across the street from the main
Pretrial
jail.
release.
Either tomorrow morning, if not, you're gonna get
No.
a warrant for your arrest. You have to be there tomorrow morning as soon as possible. All right?
Your Honor, our Spanish interpreter is here.
Okay.
On Jorge Tinarejo Martinez on page 5.
Mr. Martinez?
Okay, all right.
It's 4 cases
Jorge
ahead.
Tinajero Martinez, okay. And, Madam Interpreter, do you swear that you'll accurately and completely translate everything Mr. Martinez says to me and everything I say to him?
I do. Maria Salazar, certified court interpreter.
Okay, all right. And Mr. Martinez, you're here today charged with driving while your license is suspended.
Señor Martínez, se le acusa el día de hoy de manejar con la licencia suspendida.
As a third or subsequent offense.
Esta sería la tercera vez que tiene la misma ofensa en forma subsecuente.
In addition, you're charged with, all right, some traffic infractions that don't require bond.
También le han dado unos tickets de tránsito, los cuales no requieren fianza.
Registration and expired DL that also require no additional bond.
No tenía registración, la registración estaba vencida y la licencia también, eso no requiere una fianza adicional.
Okay, and, all right, your driving record does reflect that it's a third or subsequent offense. Bond is set in the amount of $750.
Señor, su récord no indica que sea una ofensa la tercera ofensa subsecuente y son $750 de fianza.
Good luck to you, sir.
Que tenga buena suerte.
Thank you.
Henry Ferguson.
Conti, Your Honor, he's courtroom 5840 today.
Okay.
Your Honor, if I could just have one moment, because I just want to make sure he's not being arraigned on these charges.
Okay.
These aren't even. All right, I guess we'll have to come back on it. It's not, the case number's not even showing an odyssey.
Okay, well, we'll reset it. It'll either have been or it won't have. Oren Camejo.
Mr. Camejo, come on up, please. He declined service to public defender.
All right. Good afternoon, sir. You're here this afternoon charged with a violation of your felony probation. No bond is available. I do find probable cause. You're gonna have a hearing on the VOP on August 9th. Good luck to you, sir.
Thank you. Have a good day, Your Honor.
You too. Avery Lawrence.
Mr. Lawrence, come on up.
How you doing, Judge?
I'm doing okay. How about you, Mr. Lawrence?
All right, I'm doing all right.
Okay, you're here this afternoon charged with felony petty theft. I do find probable cause for the charge. I mean, the probable cause affidavit says that there were 2 prior convictions. I assume that they were actual adjudications?
He's already, this year alone, he's been convicted of 2 thefts and 1 grand theft. On the grand theft, he was sentenced in March of this year to 210 days in county jail.
Okay, all right. I just was looking for the
Yeah.
factual basis for the felony petty
course.
theft. Okay, so I do find probable cause for the felony petty theft. Your bond is set in the amount of $750. Good luck to you, sir.
Judge, Mr. Lawrence advised me that he's homeless, he's financially indigent, but he has a mailing address. His mailing address belongs to his mother who lives in Sunrise. He's asking if you would consider pretrial release and he could get all his future court notices from his mother.
I don't think that pretrial release is a good bet here. Okay, good luck to you, sir.
Whatever you want to start with, Judge, we have the second looks and motions to release.
Okay, I mean, I'm ready to go unless anybody needs a break.
No.
Okay.
No.
No,
Judge,
no,
if we
no.
could call one gentleman out of order here at the main jail, come on up.
Sure.
He's on the 30-day ROR motion. His name is Herbert Amos.
Okay, Herbert Amos.
Your Honor, information has been filed.
I'm sorry?
Information has been filed, Your Honor.
Okay.
We filed it. So it's denied. Sorry about that, sir. You'll be probably brought to court soon. Okay? Good luck, sir. Judge,
Okay.
we're done here at Maine.
I'm sorry?
We're done here at Maine. We'll see you tomorrow morning.
Oh, okay, thank you.
Thank you, Judge.
Okay, so who's got Matthew Doty?
North Broward, Your Honor. Mr. Doty, come on out here. Go ahead and stand right here on the X. Good afternoon.
Good afternoon. Okay, this is the defense motion for release on Mr. Doty's own recognizance on 2 counts of distributing or delivering heroin, possession with intent to sell, possession of morphine, possession of cocaine, drug paraphernalia.
State has not yet filed an information, Your Honor. Mr. Doty is entitled to an ROR on these charges at this time.
Okay, then that motion is granted.
Thank you.
Okay. Thomas Rivera.
Conti, Your Honor.
All right, Mr. Rivera, on the defendant's motion for ROR, possession of cocaine and trespassing.
Your Honor, the state has not yet filed an information. Mr. Rivera is entitled to an ROR on these charges at this time.
Okay, the motion for release on his own recognizance is granted. Good luck to you, sir.
You too, man. Have a good day.
Okay. Ernest Tynes.
North Broward, Your Honor.
Thank you.
Mr. Tynes, you gotta listen to me, not them. Come on out. Come on. Ready? Stand on the X.
Good afternoon, Mr. Tynes. We're here on the defense motion for release on your own recognizance. There's a lot of charges here. Let's see. Probably don't need me to go through all of them, but there's some burglaries, some petty thefts, some resisting, some leaving the scene of a crash, driving while license suspended, etc. Have charges been filed?
Yes, they have, Your Honor.
Okay, the charges have been filed, so the motion for release on your own recognizance is denied.
Your Honor.
Good luck to you, sir.
Your Honor,
Yes, sir?
you have another one up. Oh, go ahead, out, Mr. Tyler. Go ahead and step back yourself. Lucas Bobby. He's inappropriate to bring down.
Lucas?
I don't know if he's on the 30-day or the.
Oh, Bobby Lucas, yeah, he's on the other docket.
Yeah, but he's inappropriate.
Let me check to see.
Okay.
Saying you want that as a medical reset, deputy?
Is it,
I can't say if he's going to be appropriate tomorrow. You guys can make a call on how you want to do it, but you can try to do it tomorrow if you like.
is it
I'll
a
be here
it's
tomorrow.
a medical reset?
Well, no, he's
It's up to you,
inappropriate.
Judge.
Oh,
That's up to you. He's inappropriate.
okay, well, we'll see if he's appropriate tomorrow.
Okay, and then I have one more, Capo Menendez.
Okay. That's page 4. Okay, Rafael Capa Melendez.
Come on in.
Information has been filed, Your Honor.
Okay, Mr. Melendez, the information has been filed, so the motion for release on your own recognizance is denied. Good luck to you, sir.
Thank you, Judge Fisher.
Thank
North
you.
Broward is done.
Thank you.
You're welcome.
Okay. I think we're at Donna Davis. Yeah. Okay, Ms. Davis?
Yes,
All right, and this is your motion for release on your own recognizance. The charges of possession of cocaine and possession of paraphernalia. Have charges been filed?
No, Your Honor. Ms. Davis is entitled to an ROR on these charges at this time.
Okay, the motion for release on your own recognizance is granted. There have been no charges filed.
thank you.
Thank you. Thomas Otanaga. Okay, Mr. Otanaga, on your motion for release on your own recognizance on charges of trafficking in heroin and a first-degree felony.
Your information has not been filed at this time. Mr. Ordonez is entitled to an ROR on these charges.
Okay, as the state says, no information's been filed. You're entitled to the ROR. Good luck to you, sir. Caitlin Good.
Paul Ryan, ma'am.
All right, ma'am, on your motion for release on your own recognizance on charges of possession of cocaine and possession of paraphernalia.
Information has not yet been filed. She's entitled to an ROR on these charges.
Okay, that motion's granted. Good luck to you, ma'am.
Thank you.
Jennifer Jones.
Paul Ryan. Yes, ma'am. How you doing?
I'm doing fine. How about you?
I'm good.
Good. All right, on your motion for release on your own recognizance on charges of possession of cocaine and possession of paraphernalia.
Information has not yet been filed. Ms. Jones is entitled to an ROR on these charges.
Okay. Okay. All right, that's granted. Good luck to you.
Good luck. Thank you.
We have 2 more for Paul Ryan, ma'am.
Yes. And Ruby Bray.
Yes, ma'am.
Okay, on your motion for release on your own recognizance on a charge of battery on a person 65 or older.
Information has been filed, Your Honor.
Information has been filed, so that motion is denied. Good luck to you, ma'am. Mereth Graham.
I have to go back.
Right down here.
Here, ma'am.
Okay, Ms. Graham, on your motion for release on your own recognizance on charges of aggravated assault, criminal mischief, battery, and other, have charges been filed?
Yes, Judge.
Okay. The charges have been filed, so the motion for release on your own recognizance is denied.
Can you tell us what charges have been filed?
One moment.
Number 1 is aggravated assault on an
I have
officer.
to see what actually was.
Oh, okay. Okay.
Hey, you gotta go back in there. You have to go back. Go.
Good luck to you, ma'am.
And charges filed are
Thank you, Your Honor. Have a good day.
resisting with violence, 2 counts of battery on a law enforcement officer, 1 count of assault on a law enforcement officer, looks like 3 counts of threats to specified individuals, 1 count of misdemeanor possession of cannabis, 2 counts of criminal mischief, misdemeanor.
Then I'd ask that Ms. Graham be ROR'd on all charges that were not filed, Judge.
Yes, for any charge not filed, she should be ROR'd.
Well, Your Honor, some of these are gonna be changed to charges.
Or
But I can tell
changes
you,
of charges.
If we just allow the jail will receive our paperwork today, they get the filing instructions, on declines, they ROR, it's.
Okay,
Well, the thing is, Judge, I have an order here
But
regarding
I
Mr. Mark Miller,
yeah,
where the indication
that
was
didn't
that
happen.
it doesn't always happen, and it's
Right.
certainly not Mr. Lender's fault, but it doesn't happen all the time.
Judge, that was completely different because we didn't make a filing decision on those 2 counts. We've made filing decisions one way or another on all the counts in this case.
okay, let's leave it. If there's a problem tomorrow, we'll look
Sure.
for it tomorrow,
Thank you.
okay? And I'll make sure to do it, to ROR on tomorrow on the ones that were not filed, but I see that they're different charges than were originally charged. Okay.
But I'll take a look at it, Judge. If there's any issues, I'll bring it to the court's
Please,
attention.
thank you. Okay. And, all right, Orlando Henry,
Conti, Your Honor.
okay. Okay, Mr. Henry, you're here this afternoon, charged with battery.
Your Honor, the state is just going to request that his release conditions be left in place. One, I can tell you that Mr. Henry has an open resisting without violence right now. He's already put out a trespass this year, trespass last year. Previous arrest for aggravated battery on a pregnant victim that was dropped. The allegations in this case is, one moment. He went into a restaurant, it appears, and struck a victim in the head with a wet floor sign.
Okay, and what are the conditions that he's in on now?
I'll check, but I believe it's $1,000 bond, but let me see. And obviously no victim contact. Yes, he has $1,000 bond.
Okay, Mr. Henry, on the charge of battery, I'm going to leave the conditions that were previously imposed in place. There's a $1,000 bond, and in the event that you post bond, you're to have no contact with the alleged victim. Good luck to you, sir. And Javon Springer,
Conti again, ma'am.
okay.
How you doing?
Okay, Mr. Springer, you're here resisting, on a charge of resisting without violence.
And I can tell the court the allegations are. This originated at a quick stop last Wednesday evening. Store manager advised that Mr. Springer was not allowing people to enter or exit the store by blocking the entrance. The arresting officer or deputy sheriff observed Mr. Springer leaving towards a neighboring store.
Is there some reason we can't resolve it?
No, that's why I was just giving you the.
Yeah,
yeah.
yeah.
So,
Okay, Mr. Springer, you want to resolve this case of resisting without violence with a plea of guilty?
the allegation is when he was being detained, he tensed and braced his arms, preventing the officer, the deputy, from using the handcuffs.
Sir?
Yes, ma'am.
Mr. Springer, do you want to resolve this case today, the charge of resisting without violence?
Yes, ma'am.
Okay, you understand you're giving up your right to have a trial and to talk to a lawyer. You understand that?
I had to talk to a lawyer.
I said you're giving up your right to have a trial and to talk to a lawyer about these charges. You understand you're giving up those rights if you plead guilty today?
Yes, ma'am.
Okay, I'm going to accept that plea as knowingly, intelligently, and voluntarily made. I'm going to adjudicate you guilty, sentence you to time served. Any court costs, you'll have 180 days from your release from jail to get those paid.
Okay.
And no return to the Quick Stop, was it?
Yes, ma'am.
You know which one?
Yes, ma'am.
It's the Quick Stop on excuse me, 199 West Hillsborough Boulevard in Deerfield Beach.
Okay, the West Hillsborough Boulevard in Deerfield Beach. No return there. Don't go back there.
Yes, ma'am.
Okay, good luck to you, sir.
Thank you, ma'am. We're doing it, Conky.
Okay. Got him. I think, is there anything else that needs to go on the record?
Hopefully so, Judge.